Okay, welcome everyone. We're going to go ahead and get started. We hope you didn't have any technical difficulties getting logged in, but we are excited for today's presentation. We have one of our great partners in the estate planning world, and he's really turning into a good friend, Andrew Alliston, with us today from Anderson Estate Planning. And he's going to share some really great and pertinent information on some of the things that they do every day and that they see every day with some of the difficulties and challenges that people face with estate planning. So if you're new to us, we are Abiding Wealth Partners. We're a full service financial planning organization. My name is Jason Jupiterwala. I'm one of the partners along with Sean Scruggs and Matt Swarbrick. And we help our clients with really every stage of their financial lives, from what we're going to talk about today with the estate planning to managing their retirement goals and objectives and helping them to reach those. So I am going to turn it over to Andrew, and we hope you enjoy the presentation.
All right, good afternoon. I'm happy to speak to all of you today. Thank you, Jason, for the introduction. I really enjoy doing these presentations because I feel that there's a lot of people that have some information and have a lot of questions about just kind of the basics of estate planning, as well as other people who have a lot of misunderstandings and some misinformation about estate planning. And so today, what I'll be doing is a couple things. First, just kind of introducing myself and our firm, who we are, what makes us different, and then spending the most of our time educating you on the basics of estate planning. We'll be talking about wills, probate, trusts, and what the difference is between them, why people do some over the other, and hopefully really help you feel comfortable in these areas so that you as an individual or as a family can make good decisions for yourselves. And near the end, I'll be sharing some testimonials of clients that I've worked with. Obviously no specific information, but I will be sharing just some kind of fact patterns with you, more or less stories to be avoided. But I think it's helpful for people because in theory, some of these things can be difficult to understand. And so when you put people and facts and real life into it, it usually holds more water for people. So just a brief introduction on myself. My name is Andrew Alliston, and I'm an attorney at Anderson Estate Planning. We have 5 attorneys currently who all do the exact same thing, which is estate planning and asset protection on one side of the firm and probate and guardianship on the other. What we're talking about today really is the planning piece, right? How can we plan in a time of peace so that we know what's going to happen when something happens to those that we love or to ourselves, right? But we also handle probate and guardianship, which are the court pieces to our everyday world. But what's important about that for the public to understand is that we jokingly tell our clients, we don't do your third cousin's divorce, your traffic accidents, your slip and falls. So this is our lane, and we are good at it. We stay in it, and we are effective for our clients, which is very helpful. You don't want an attorney experimenting with your family, or with your planning. So that's a little bit about the firm and the focus. We flat fee everything we do, which is pretty typical for law firms. But what's different is that once we engage with a client, whatever they've engaged us on, whether it's a will or a trust, that fee is all inclusive. So what I mean by that is that, when you're having your annual review with Jason and his team, and something comes up, you or Jason can pick up the phone and call me and say, hey, how would this impact their current estate plan? And we can talk about it, and you're not getting a bill for it. So conversations, emails, future changes to your documents that are with us, it's all included. And we do that intentionally so that all of your planners can be on the same page and make sure that you're actually hitting the goals that you aimed for. So that's very different. But anyway, enough about us. Let's go ahead and get started. So There are three basic tools when it comes to estate planning for most families, and that is the basic will, a testamentary trust, and a revocable living trust. Most people have heard about wills. Most people have heard about trust, at least a variation of a trust. The testamentary trust is very confusing, but that will make sense in a few minutes. So what I'm going to do is kind of walk you through each of these tools and kind of help you understand the pros and the cons of each, why people use them, why people don't use them, and how it might fit with you and your family. So to start out, a basic will, what is it? Well, a basic will is what most people think it is. It's about 4 to 6 pages long. It says, if you're married, everything to your spouse. If you have kids, it says, then down to my kids if my spouse isn't here. If you have minor children, you're going to appoint a guardian as well, regardless of children, as well as a executor and a backup to an executor. And that's it. You sign it, you date it, you get a notary stamp on it, and then you stick it in a drawer and you wait for something to happen to somebody. So it's very simple on the front end. And that's one of the two words that we'll talk about with each of these plans is simple and control. Simple because everybody wants things to be as simple as possible when things start to happen. And then the other thing is people want at least a little bit of control, so much as it doesn't outweigh the simplicity or complicate things too much. So for a will on the front end, with the planning piece, it's extremely simple. We're doing very minimal planning, and then we're mainly waiting for the work to be done till later. From a control standpoint on the front end, it's a little bit of control because without it, you divert to the state rules, which are called the Rules of Intestacy. And all that means is you don't have a will, and now the state is going to say where things go when somebody passes away. Now, when something happens to somebody, that's when the will kicks in. Another name for a will on the attorney side is an on-death document. And so this will doesn't do anything until something happens, and then it activates. So when it activates, that's when we do all the work. So when somebody passes away, now it's not so simple because now we need to do a lot of work. And also from a control standpoint, you have a little bit of control because you're saying who you want to be in charge of the process, your executor. You're saying where you want your things to go and in what shares. So that's good, but you're still submitting yourself to the court and to the probate process. So it's not that much control. Now, that brings up a few things that we need to talk about. What is probate and what does this exactly mean? So with a will, 9 times out of 10, if you own a piece of real estate, which is a house, right, or anything else, the dirt in the ground, it will trigger probate. Now, what that is, and the reason it gets triggered is anytime we have a name on something on a piece of paper that cannot be transferred with a beneficiary. So your bank accounts, they're transferred with beneficiary designations, IRAs, beneficiary designations, but real estate doesn't really have that function for the most part. So you have a deed in the clerk's records and with 2 names on it for a married couple. When one of the spouses pass away, it does not mean that the other spouse automatically gets the entire property because the will says so. The will does say so, but you have to go through the probate process, which is in front of a judge, appointing an executor and giving that executor the authority to sign on behalf of someone who's no longer here. So that's why we have probate. How are we going to transfer something in someone's name who's no longer living, right? Who's going to be that person and how do we administer it? That's what probate is. So like I've been saying, some assets go through probate, some don't. What typically avoid probate are your accounts, your bank accounts, your retirement accounts. Usually they will avoid it with beneficiary designations. What does not avoid it usually are businesses, real estate, and vehicles, things like that things that have title and paper and names attached to them. Now, what does that mean? Well, if you're an individual, you're not married, and when you pass away, you have one probate. Everything is going to now be transitioned to those that you've chosen, whether it's family members or charities or whatever. When you have a married couple, that's 2 probates. One probate when the first spouse passes away, And then the second probate, when the second spouse passes away. So the first time you're consolidating everything to the survivor. And the second time you're consolidating all of it to kids or grandkids or other family members or charities. So that's 2 probates for most families. Now, that also means, remember I said dirt in the ground triggers probate. So every state controls its property. So if you have multi-state property, say you live in Texas, but you have a vacation spot in Broken Bow, Oklahoma, or a timeshare in Florida, or a rental property in California, you now have triggered probate in every single state that you own property times 2, if you and your spouse own it together. And that is very complicated, and it is very expensive for most families. So probate is not a bad thing necessarily, but it becomes very inefficient when you have multiple states getting involved. So that's one downside. Another downside to probate is the time. It takes about 6 months to 2 years to get all the way through probate. And that is a long time for people to be dealing with these kinds of things. And usually people just want it to be done. But there's regulations and different things that have to be adhered to. And so the average time that it takes a family to get through probate is about a year. And now it has its peaks and its valleys, it has its start and its stops, but on the whole, you're kind of messing with this thing on and off for a year. And then the other downside is the cost. Currently, we charge $5,500 to go through probate one time. So again, married couples, that's 11 grand essentially to get everything first to the survivor review and then to the next generation or whomever you're leaving it to. And for most people, when they hear that number, they think, oh my goodness, that is a lot of money when we're talking just a simple will, right? And that's what most people tell me. We're not complicated. We don't have, a whole lot of variations with our assets. We're pretty straightforward. But what they don't realize is that with a will, straightforward or not, it's going to cost a good amount of money to transfer assets because you're going through that court process. So just something to be aware of. And then again, if you're doing that plus other states, it can climb very quickly in the multiple tens of thousands to transfer. One of the other downsides with probate is it's public. So people don't really realize this. They'll start to get calls from estate sales, house liquidators, people trying to collect debts and those kinds of things. And they ask me as the attorney, who did you give our number to? And I say, I did not give it to anyone. This is a public process, and the public has a right to have certain information. And so you're out in the open now. And so for people that don't like that, this is just something to be aware of. It's not overly invasive, but it is something. And the final piece for most families is that you cannot delay a distribution through a will, a simple will, beyond the age of 18. What does that mean? So if you have young kids and both parents pass away, now you, number one, have to have a guardian appointed over your children because they cannot, they're still minors, but they cannot inherit as a minor. And so now that guardian is approaching the court or a custodian of those funds until the kids reach 18. And then at 18, the court or custodian says, congratulations, you're now an adult. Well, most 18-year, I would not classify as an adult, but most of them are really bad with money. And this is just one of the limitations of a basic will. There are ways to fix it, but this is one of those limitations. So it's just helpful for people to understand that. Okay, so that's a basic will. So extremely simple on the front end, not so simple when something happens to somebody because we have a lot of work to do now. A little bit of control on the front end, not so much control when you hop through the court processes. So that's the first point. The second tool is a testamentary trust. Now, this is the most badly named vehicle that we have in our arsenal. It is not a trust. This is a will. And so another name for a will is a last will and testament, which is why we get that word testamentary. So testamentary trust, what we're doing here, this is a will, and inside of this will, we have put trust language, but it's contingent. So what that means is it's springing, or think of it, you can kind of turn the faucet on or off if you need to. And so the way this would operate is for those families that have kids, or say they're not necessarily kids, say they're 19, 20, 21, but they don't feel that their children are ready to handle any kind of an inheritance yet. Well, now those parents can say, these are the ages that I want my children or my loved ones to receive their inheritance. And you pick those ages. It can be 25, it can be 45. You can do a range. You can do 25, 30, and 35 and percentages at each age. So basically, it puts the parents back in the driver's seat from a control standpoint. So that element of control that they lost with the basic will, they gain with this type of a will. Now, how does this really play out? A couple different things. First of all, you don't deal with this at all when the first spouse passes away. It just consolidates to the survivor, the widow. And then when the second spouse passes, at that time, the judge and the executor will look at the children and their ages. And if any of their ages are underneath those thresholds that are inside the document, at that time, a trust is created out of that language. Then it's filled with the inheritance. The trustee who's in charge of that trust and its assets then follows the rules that the parents have put in place for their kids, and they take care of their children until they reach an age where the rules say they can take it. I know it's a lot of information, but let me walk you through that a little bit. So say both parents pass away, a random car accident or something like that, and then they have an 18-year-old, a 15-year-old, and a 12-year-old, and their ages are 25, 30, and 35, and kind of a third at each age. Now, what happens is the guardians are appointed, a trust is created and filled up all the way with everything, and then all these kids are at least 8 to 10 years from getting anything under those lump sum ages. But what about their basic needs? So there is an acronym that we use in planning, and it's called HEMS, HEMS, and it stands for healthcare, education, maintenance, and support. And so what that acronym says to the trustee, the person that's in charge of making sure their needs are met, is that these items, these categories, you cannot say no to the beneficiary. So if the kids need healthcare provision, whether it's insurance or surgery or extended care, whatever it is, the trustee cannot say, no, I'm sorry, I'm saving your inheritance and I'm not covering that. No, it says healthcare, you have to cover healthcare. Education, you can limit it or leave it wide open, but they cannot say, no, I'm not paying for your college, I'm not paying for private school, those kinds of things. They have to cover education. Maintenance and support is roof over your head, food on the table, heat turned on, transportation, the basic needs of daily living. So again, the trustee has to meet all of these needs. So what happens is the trustee is just providing privately, not through the court process once this is set up, but privately making sure all those kids' needs are met at any age. And then once one of them hits that age threshold, 25, for example, then at 25, they get a lump sum distribution, but they still have not received all of their inheritance. And so until they are completely zeroed out, the trustee's role is to make sure that their needs are met. So for example, say the oldest child spends their 25, their inheritance at 25 on, they invest in a bar, which has happened. That's not a fake story. In Austin, Texas. And then even though it was a sound investment, according to all of their friends, the bar goes under, as a lot of bars do. And then they are now poor again. They can't make their rent. They can't pay their bills. Well, the trustee still has to cover these things because they are those basic needs, maintenance and support. Now, all they're doing is covering their needs for another 5 years until they get another lump sum distribution at the age of 30, and then they get another bite at the apple. And so the goal is to not just load everything on these children at one time, is to give them basically a swing and see how they handle it. And if they miss completely, well, you still have the lion's share preserved of their inheritance, and then hopefully they learn some valuable lessons. Hopefully they work with Jason and his team to make sure that they are not wasting these resources, but that this is kind of the dynamic, how this works. So on the front end, this is still extremely simple. There's not that much planning we're putting into it because we're just putting some ages in there, we're putting some language in there, but it's all contingent. It may never be used, it might be used, we don't know. It's a little bit more control because you're dictating to the court when people get things, but you're still submitting yourself to the probate process. So best case scenario, you're still going through 2 probates. Worst case scenario, you're doing 2 probates and creating a trust after the fact. So from an efficiency standpoint, this can be a very expensive option if you have to jump through all of those hoops. But from a control and peace of mind standpoint, for most families, this can be a very useful thing because they have the comfort knowing that their kids will be taken care of by the people they want in the way that they want if the need arises. So that's extremely important. So again, sorry I didn't pop through these as I was talking. This is not a trust. So a lot of clients come to me and say, we have a trust. And I look at it and I say, no, you have a will with trust language in it if it's needed. So that's very important. It's still a will. And again, it's young kids, but again, you just have to remember mind. That's option number 2. Option number 3. So this is, I think, was most misunderstood, the revocable living trust. I get 2 reactions when I talk about a trust. One reaction is, why do we need a trust? We don't have enough assets to justify it. Or, this is too complicated. We're straightforward people, those kinds of things. And then occasionally people say, hey, we're not the Kennedys or the Rockefellers, so what are you talking to me about a trust for? So let me break this down a little bit. The first word is revocable. So all of these plans that we're talking about are revocable, which means you're in full control. You can change it whenever you want. You can swap out people, beneficiaries, who your trusted people are. So you're not locked in any way, which is good. The second word, though, living, revocable living trust. This is the difference. A will, remember I said, is an on-death document. A trust, so it doesn't kick into gear, the will, until somebody passes away. A trust is living. So the minute you sign it as an individual or as a family, a couple, then you have now created this trust, which we refer to as attorneys as an empty box. And then the next step is to now fill that box with everything that you have. Your house, your businesses, your bank accounts. Qualified money cannot go inside of here. So we designate beneficiaries is contingent. So still spouse first on your 401k, still spouse first on your IRA or your annuities, those kinds of things. But as a backup, instead of having your kids in equal shares, or what do we do if our kids are minors, we just put the trust as a backup because the trust is living. It does not die. And so if something happens to both of you, it defaults to the trust, and then the trustee privately has the ability to administer the funds as necessary. Now, a couple things about this. First of all, the revocable living trust is designed to avoid probate for an individual, for both spouses, and this is very important. Now, how does it do that? Well, it only avoids probate for everything that is inside of the trust. So you have an executor that's in charge of a probate process that is appointed by the judge. They have control over everything. They do everything. With a trust, with a revocable living trust, you have a trustee. It's the same kind of a role. They only have control, however, over whatever is inside of the trust. And as an attorney planner, I find that most trusts that come to us, most clients with trust who come from other firms have empty trusts. In other words, the attorney drafted it, handed it to the client, and then said, congratulations on your revocable living trust. Have a nice life. Oh, just remember you need to fund this. And the client goes, okay, nods their head and doesn't really understand what that means. And so until you draft a deed that makes sure that your house is owned by the trust, until you make sure that your business documents are updated with the trust owning them, until you make sure that your bank accounts are now titled in the name of the trust, Until all of these things happen 100%, the trustee does not have control over them. And unless it's 100%, the trustee will not be able to access those other items after you pass away, which means you now go to probate court. And that's the whole reason that people do these, is to avoid it. So that's one of the differences that our firm, I think, stands out in. Anytime we create a trust for someone, we are funding it fully. So we're drafting deeds on real estate, we're assigning businesses, we're writing letters to banks, financial advisors, plan administrators. We're making sure that everything is now tied directly or indirectly to the trust, so that when something happens to somebody, there's an automatic power transfer from trustee to trustee. There's no judge, there's no attorney, there's no court process. And that's a very, very, very big deal. So for those of you who wonder why people do this, it's primarily probate avoidance. And for those of you that have existing trust, what you'll need to do is make sure that it actually is filled up. Because if it's not, it doesn't do anything. And if it's halfway filled up, there's no E for effort. It doesn't work. And so you still end up in probate, which is a difficult thing. Not only in Texas, but every state that you own property, a trust will avoid probate. So for those of you who have that broken bow, getaway home on the weekend, or if you have a rental property in California or a timeshare in Florida, as long as all of those deeds are properly reflecting trust ownership, you don't do probate in any of those states, which is extremely efficient from a time standpoint and also very cost effective. So that is a humongous benefit of a trust. And again, this only happens to the extent the trust is funded. I know I keep saying that, but this is where most people tell me that it is, and it is not. So very, very, very important. It's kind of the name on the check rule. So if you see your personal name on something and it doesn't have trustee behind it, then it's not properly titled. All right, some more things. So again, a will is a public transfer, right? So that means the public has access to the documents, the will itself, any kind of an inventory. They can show up to the hearing. It's under the public eye. The trust transfer is a private family deal. Everything happens through this document and privately with the family. There's no judge, no attorney, unless you want, for example, if you're our clients, and if you want our advice and help, we can help, but you don't need our permission. And again, from a simplicity standpoint, the trust on the front end is the least simple, but we are doing the work. So it's not to put burden on you as a client. It's just why it costs more, because we're doing a lot of legal organization as well as asset transfer on the front end. And the reason that this is good is so that when something happens to somebody, it's incredibly simple because everything's already been organized under one roof. The trustee has the authority. They don't need permission from anybody. You just show a death certificate and the trust document that shows that you are next in line. And then this is another huge deal. So in probate, the way the law is structured is to provide an avenue for creditors to be made whole. So creditors actually have priority over family members in a probate process. What do I mean by that? If there is credit card debt, loan on a mortgage on a house, medical debt, things like that, when both spouses have passed away, the kids hopefully will receive an inheritance, but all of those things that I mentioned, they get made whole first, and then whatever's left goes to the family. With a trust, when both spouses have passed away, now the way that we draft it is the trustee has they have preference. It says the trustee may pay these types of things. And so now the trustee can decide, am I going to pay this credit card bill? Am I going to pay this, medical end of life bill? Whatever. And if they're small, if they're reasonable, they're going to pay them because that's how we are as people. We want to be honorable. But if it's a question of do Bob and Sue, the children, are they going to get their inheritance, or does Baylor, Scott, and White get their bill? If it's either or, we can't make both happy, then the trustee has the ability to prioritize Bob and Sue, and there's no legal liability that the trustee has, and there's no liability that Bob and Sue have. That's just the way the law works. So very, very important dynamic there. a few more things. Remember, I said with a basic will, you can't delay a distribution beyond the age of 18. With a trust, everything's inside of it. When it's properly funded, the trustee has automatic control, and now the trustee can make sure the needs are met of the beneficiaries until their ages are attained, and it's all handled privately, so there's no court involvement at all. And that is a really big benefit for families. Couple other things. So for those of you, or let me say, for those of you who have neighbors or friends that have these problems, because we don't have these problems, but for those of you that have these issues where you have a kid who's just really terrible with money, the trust gives you the ability to make sure that creditors don't have the ability to leverage those assets inside of the trust. So as long as it's still inside the trust, it's protected from creditors for those kids who have spending issues or lots of debt. And then it also can help protect against those that have addiction issues. If a divorce is coming, you don't want to throw a lot of liquidity into a divorce, because it will most likely be lost, even though technically it's separate property. Attorneys get involved and it doesn't always end well. So there's a lot of other options with a trust. And the last thing that I wanted to point out, for those that have children or grandchildren with special needs, we can build language inside of this that's contingent, that says if any of the beneficiaries have or will be applying for government-based benefits, then this money, this inheritance is not available to them directly in any way, which means they still qualify for government-based benefits, and the money is available to increase their standard of living. So that is a great thing. It's not an either or option anymore. You can do both. So when it comes down to it, with these revocable living trusts, again, extremely so not simple on the front end, because we're doing all the work, we're organizing it now. Very simple when something happens to somebody, because we're just changing who that person is in charge, the trustee. From a control standpoint, it's maximum control now, because you're in charge as the trust maker. It's off your social security number. There's no separate taxes, and you can change it anytime you want. And then when something happens to you and or your spouse, it's also maximum control, because you're staying out of the court in every state that you own property. And then you have all of these ancillary benefits that you can structure it however it needs to be structured to bless your family in the next generation. So anyway, all of these tools work. There's nothing really wrong with any of them. They all do the job, but they go about it very different ways. And I find that most people, once they understand how they work, usually most people gravitate towards one or the other, depending on their mindset. So hopefully that was helpful, just to help you understand how these operate. What I want to do now, before we end, is share with you a couple of testimonies based on a few scenarios. So think of this as kind of a case study. So the first one is no will. So remember I said it's called intestacy when you don't have a will. I had a client who was not married, had no kids, was a U.S. citizen but born from another country, and they passed away unexpectedly, and had I would say substantial assets. They had some property, they had some liquid assets, those kinds of things. So this person's dad came to me, hired me to probate his son's estate. And so I started asking him some questions. I said, okay, did he have any kids? Was he married? No. Okay, well, this is the way the law works. His entire, everything that he has will be split into 50-50. Half of it will go to you, Dad, and then half of it will go to his mom. Are y'all still married? What's the situation? No, we were divorced. Okay, not a problem. It goes to her. And he said, well, there's a slight problem. Mom is not here anymore. She passed away. I said, okay, well, it'll go to her kids. Is that the same kids that y'all had together? No, she was remarried and then had all of these half brothers and sisters to the decedent, my client's son. So here's how this played out. Dad, before son passed away, advanced an inheritance to son in the amount of like $300,000. Now that $300,000 only it gets split in two, and 150 of it goes not to ex-wife, but ex-wife's new kids, who the client's son may not have even known about or even liked them. And he looked at me and said, "This is not how my son would have wanted this to go down." And I said, I guarantee you it's not how he wants it to go down. But when you don't do any planning and you have complicated family dynamics, this is how it plays out. So the law is not perfect. It does its best to try to cover all of the scenarios. But if you have any kind of a complex family dynamic and you do not have a will, it will not end well, is the best way to say that. So hopefully that's just helpful. Not trying to scare people, just trying to help you understand kind of what things do. So that was a single person. Now, same dynamic with a blended family. So this was husband, wife. They had a child together, and then the husband had kids from a prior marriage. Husband dies unexpectedly. They owned a business together. Now, here's the problem. All of husband's previous kids from previous marriages are all minors, which means that all of his exes now are guardians and representatives of those guardians. So now all of those exes are business partners with my client, the wife. And that is not a place any business owner wants to be or ever thought that they would be. And so it created an extreme burden for my client to figure out, what in the world am I going to do? Do I close the business? Do I try to keep the business going? And unfortunately, most of these ex-spouses were not really in it for the children. And so they were just kind of in it to see what they could get out of it for themselves. And that happens, right? So when we look at it as people, we can see, well, that's not a good situation. I don't want that person to get money. I don't want that person to be in charge. But when you don't do any planning and you have any kind of a wrinkle in your family, it can create vastly unique outcomes that are usually not good for people. So now let's talk about, there was a client that I helped. There was a will. There was a beneficiary, but this beneficiary was a fully disabled adult who was currently on government-based benefits. And so her aunt left her a house to bless her, right? It was a good thing. The problem is she left it to her directly. There was no language in it like what I talked about for those who are on benefits. And so it instantly kicked her off of her government-based benefits. And it was only enough to cover her for less than a year. And any of you who have any experience in this space, it's very difficult to get approved for benefits. And then if you get kicked off, it's very difficult to get reapproved. And so it's not like you just apply 1 month and you're back on. You can have many months of gap, which is very difficult for families. And so it's not bad to leave things to people, but this is why I always encourage clients, to talk to someone who is a human that can evaluate the dynamic of the family, because this is something that Rocket Lawyer or LegalZoom is very bad at. They don't understand fully your situation, and they can only program so many prompts. And it's the family dynamic almost always that dictates the kind of planning that we do and how we need to handle certain situations. So the last example I wanted to share with you is a client who came to me. We did not do the planning initially. And she came and said, my husband passed away a few years ago. I just need to make a few updates to my trust and sell my house. And I said, okay, let's talk about that. What's inside of your trust? And like I mentioned earlier, she said, everything's inside of my trust. And I said, okay, I believe you, but let's just do our due diligence and double check. So we looked it up, and it was still in her and her husband's name individually. And I said, okay, let me check your bank statement. It was her name individually, which is okay. I mean, she's still here, so she has control of her finances. But the point was, the trust was not funded partially or fully at all. Now what we needed to do in order to fund her trust, we had to first go through probate for her husband, which can be difficult after a few years. So in Texas, after 4 years, a will expires. So it can create problems when survivors just kind of hang out. They have control of their bank accounts, and so they don't think they need to do anything. And then they go try to sell their home 8 years later, and the will that they had no longer is valid. And it's just a more complicated scenario. So again, we were able to help her, but she was extremely frustrated because, at least initially, because she said, the attorney told me that I would avoid probate. And I said, I understand, but the subtext of what he told you is it has to be funded, and he didn't do it, which is pretty common. It's just something that we always do. So just, I think the moral of the story, I don't think I have any more tests. Yeah, that's it. I think the moral of the story here for those of you who are attending today is really to make sure for you and those that you care about, whether it's in estate planning, whether it's in financial planning and wealth management, taxes, it's really, really important that you get your advice from people that are experts and that you trust to give you a good education, so that you as an individual can make an educated decision. And so that's really the goal today, is to kind of pull back the curtain, help you understand with some real life stories of different things that can happen. Maybe it resonated with a few of you. And then for the rest of you that maybe nothing wrong has happened yet, but just help you understand what you maybe do or don't have, or why planning is so important. So I appreciate y'all taking time out of your lunch hour to join in today. If you have any questions in the future, or you'd like to schedule an appointment with me, here is my contact information. I'm sure also Jason can kind of forward your info along. But with that, I'm going to pass it back to Jason, and thank you so much.
Thank you, Andrew. That was fantastic information. I know that I learned something. And I also learned that I'm glad we have Andrew and his team in our corner, because these are very complex and complicated issues. And we're happy to have them as kind of a sounding board when cases like this come up for our clients, and we need some insight. So like Andrew said, if you do have questions, we are actually recording this. So feel free to reach out if you would like a copy of that recording, if you'd like to go through any of the information again. But Andrew is also available. So you can go straight to the source and schedule a consultation with him, either by reaching out directly to him with that information, or reaching out to us, and we can pass you along over there. So thank you so much, everyone, for attending. We plan on doing more of these educational events throughout the year and into the future. So if you have any feedback, we would love to hear it. And we are just glad you were able to log on today, and we hope you take care and stay safe out there, and we will see you next time. Thank you.